An Ashtabula man who is accused of stabbing his wife to death Tuesday said in Ashtabula Municipal Court late Thursday afternoon he wants the legal process over as fast as possible to spare his children. John McEndree of 1321 Allen Avenue is charged with 1 count of murder and unclassified felony in the death of his 48-year-old wife, Deborah. Authorities say he also stabbed himself in what appears to be a murder-suicide attempt. The couple was found by their daughter. City Solicitor Michael Franklin filed charges just before the suspect was brought to court. Judge Laura DiGiacomo boosted the bond requirements because not only is McEndree charged with murder, but parole violations involving 2 thefts that he was sentenced for earlier this year.
John McEndree. This is in the matter of State of Ohio versus John McEndree. We are scheduled for an arraignment today. Mr. McEndree is present in court. The State of Ohio is also present, represented by Attorney Michael Franklin. This is in regards to case number 15 CRA 00663, State of Ohio versus John McEndree. Mr. McEndree, have you received a copy of the charges?
Yes, ma'am.
I'm going to read the charges to you and make you aware of the potential penalties associated therewith. On or about the 12th day of May 2015, in the city of Ashtabula, county of Ashtabula, and state of Ohio, one John P. McEndree did purposely cause the death of another, to wit, Deborah L. McEndree. This is a murder charge. It's in violation of Revised Code Section 2903.02a. It's an unclassified felony. If you are convicted of murder, you will be sentenced to an indefinite prison term of 15 years to life and a potential fine of up to $15,000. Do you understand the nature of the penalties associated therewith?
Yes, ma'am.
And the charges. I also must make you aware of your constitutional rights. You have the absolute right to remain silent. You need not make any statement at any point in these proceedings. And if you do make a statement, that statement can and may be used against you. This is commonly referred to as your Fifth Amendment right against self-incrimination. You have a right to a jury trial, although that will not take place here. You have a right to confront and cross-examine witnesses against you at that trial. You have a right to compulsory process for obtaining witnesses in your favor. You have the right to require the state to prove you guilty of these charges beyond a reasonable doubt at a trial where you cannot be compelled to testify against yourself. You have the right to a reasonable bond. You do have the right to an attorney. If you cannot afford one, the court will appoint you one. You have a right to a reasonable continuance to secure counsel as well. Because this is a felony charge, you have the right to what's known as a preliminary hearing. The procedure in this court is that a preliminary hearing will be scheduled within the next 10 days. A preliminary hearing is a probable cause hearing to determine if a crime was committed and if the appropriate person was charged with that crime. If probable cause is found at that hearing, the case will be bound over to the grand jury for further proceedings. Do you understand your rights as I've explained them to you?
Yes. Can I ask a question? Or should I wait?
Go ahead.
When I come in for the preliminary, can I be sentenced then?
No, that's just a probable cause hearing. This court will, if the
If I
probable
defer?
cause hearing is determined, the case will be bound over to the grand jury, and then that'll proceed to the Court of Common Pleas.
Okay, I just didn't want to put my children to a bunch of rigmarole. I just wanted to get it over with.
Okay, well,
I understand the
we
procedure.
can't do that at this point in time, okay?
Thank you.
Now, because you do have that right to a preliminary hearing, I'm not going to enter a plea today. Okay, I'm only going to take up the matter of bond today. So does the state of Ohio wish to be heard on the matter of bond?
Your Honor, in light of the seriousness of the charges and our assessment that Mr. McEndree may pose a threat to his own safety and possibly to the safety of others, we would ask the court to consider imposing a bond in the amount of $750,000 cash or surety.
Anything you wish to say, Mr. McEndree? Okay. Now, Criminal Rule 46C does lay out the factors to consider in determining types, amounts, and conditions of bail. And they are as follows. Court is to consider the nature and circumstances of the crime charged, the weight and evidence against the defendant, the confirmation of defendant's identity, lists and factors tending to show defendant is unlikely to abscond, his family ties, employment, financial resources, character, mental condition, length of residence in the community, jurisdiction of residence, records of convictions, record of appearance in court at proceedings, record of flight to avoid prosecution, and whether or not the defendant is on probation, a community control sanction, parole, or post-release control or bail. I know that a probation violation has been filed in this matter. Did you receive a copy of that yesterday?
No, but I did receive I came in 3 pieces of paper for the charges they already had. And they said I did warrants off me, but they were already settled with me and you. So I don't know why there's still a warrant.
So I'm going to go ahead and go over with him the probation violation as well. Okay. Mr. McEndree, you have been served with the probation violation. Basically, it is alleging that on May 12, 2015, the defendant allegedly murdered his wife and was arrested by the Ashtabula City Police Department. It also alleges that in Section 5, I will comply with all the orders given to me by my probation officer and/or any authorized representative of the court, including any written instruction issued any time during the period of my probation. They're also alleging that you will agree to follow any conditions imposed by the court or the adult probation department. It states that the defendant was ordered by the court to complete a theft class and comply with IOP at Lake Area Recovery Center. And it also alleges that Mr. McEndree has not registered for the theft class as of this date and has failed to attend IOP on May 4th, 2015, May 6th, 2015, May 7th, 2015, May 8th, 2015, and May 11th, 2015. So,
I was going to the theft class too.
okay, I want to hear any details of, I'm going to enter a not guilty plea on your behalf. With regards to this violation for probation, it does subject you up to 6 months incarceration because that was the period that was suspended back in March. You understand that?
Yes.
Okay, I am going to enter a not guilty plea on your behalf for that charge as well and set that for a probable cause hearing. Now, Mr. McEndree, will you be hiring your own counsel or will you be requesting court appointed?
Court appointed.
Okay, we'll get you the paperwork to do that and I will appoint counsel for you. And there were 2 counts of probation violations filed under case numbers 15 CRD 226 and 15 CRA 194. Okay. I have considered the state's recommendations as well as the factors listed in Rule 46C and find that because of the seriousness of the crime charged, the safety risk you present to the community, as well as yourself, and the risk of flight, I am going to set bond in case number 15 CRA 663 with the charge of murder in the amount of $1,200,000 cash for surety bond, scram as a condition of bond. In the matter of the probation violations in each, I'm setting bond in the amount of $25,000 cash or surety bond, scram as a condition of bond. Help me out.
Thank you, Your Honor.